Uh-oh.
Did you do I would do the cloud.
I think that's what I did. Okay. All right.
We'll find out.
Yeah, I'll just take my computer and give it to you. Oh, I got 2 people in the waiting room, so we will admit them. And I'm going to mute and let Scott take it away because he has a lot of really wonderful stuff, I guess. Not really, but important things to impart to us.
Thanks, Julie. Hi, everybody. I think a lot of you do know who I am, but I will, since we're being recorded, there's a glowing red dot on my screen that will constantly remind me that this is not just for us. This is for posterity. And so I will see how long I can get into this before I start cursing. Anyone wants to put down some bets, I've got it at like 7 minutes, and then the F-bombs will probably start coming, but I'm going to try, maybe save that until we turn off the recording, and then I can tell you how I really feel about some of these things. As Julie mentioned, I am what am I? I am the assistant director of the Illinois Juvenile Defender Resource Center, which is a very small subset of the Office of the State Appellate Defender. So Illinois does not have a statewide public defender system. We have 102 counties, and so we have 102 different versions of PD offices throughout the state. And so when the General Assembly wanted to create something whose mission is to sort of provide support to attorneys statewide, OSAT is kind of the only game in town in terms of a statewide organization providing, doing anything sort of from that level. And so when we created an organization to sort of help attorneys who are working on a specific type of case, that is why I now am back at the Appellate Defender's Office, but I don't represent clients. My work is to help attorneys and individuals, any attorney working on a case involving a kid. My job is to try to help however I can. And since that is pretty much what I had been doing for the last 10 years, working specifically on the issue of kids facing and serving long sentences, this has been sort of a natural progression into this work. Julie, how long should I just be talking? Because I'm a goldfish and I will take up whatever size bowl you put me in.
Well, the meeting is 1 to 2, but many of us don't mind staying overtime. So as long as you can. Right?
Sure. Yeah. That will, like, we'll just start to see these windows drop off. Like we've got a nice healthy crowd right now, but like, I'll be vamping on some preposterous thing, and we'll just start to see windows close and close and close. And so what Julie asked me to talk to you all about is sort of what's happening in the courts right now. I like to use visual aids. And so this is the water glass that I'm drinking out of today. Usually I like to talk about whether or not my glass is half full or half empty. Right now, Julie's glass is on its way to empty in terms of her viewpoint and sense of how these things are. I am going to prevent you from knowing just what I think about, am I optimistic about these things or am I pessimistic about these things? I'm going to keep it. It's going to be between me and the Yeti as to, what my ultimate spin is. But since I also don't like to keep secrets, everything sucks right now in the courts. And so if we're looking for a quick headline, things aren't great. But we can unpack some of that, and we can still sort of talk about what still remains, and sort of what the reason why y'all getting together and sort of the power that is on this Zoom screen really matters, and will continue to sort of make things better by virtue of the broader work that you guys are focused on and the work that you all are doing. So. It's been a while since I gave this kind of an update to this group, and I know that I probably will do a little bit of repetition. So bear with me for that. But you know, we have to sort of begin, and also I'm going to spend most of my time talking about what's happening in the highest courts, so both the U.S. Supreme Court and the Illinois Supreme Court, because they basically dictate what happens everywhere else. There are good things happening in the appellate court. There are bad things happening in the appellate court. But at the end of the day, none of that is necessarily going to amount to a hill of beans based on what's happening in these higher courts. And the same is true actually down in the circuit courts. Like I talked about that Illinois has 102 counties. One of them is Cook. Cook is massive, and there are so many courthouses in Cook. And so there are great things happening in some of those courtrooms in Cook County, and there are awful things happening in some of those courtrooms in Cook County. And we just don't have our hands around everything because it would be impossible to fully track each and every instance in which a case is sort of coming up. But know that just because I say something does not mean that something good or something bad may not happen. Because I hear all the time about like, well, but they somehow got through. And it's like, the reality is, yeah, sometimes something positive can happen down in the trial court because that's just the power that those courts have. But in terms of sort of the overarching work and the overarching sort of concerns that this group has, it does matter sort of what these highest courts are talking about. So you all know sort of the progression of big U.S. Supreme Court decisions that sort of have brought us to that sort of joined this group together. The biggest of which being Miller v. Alabama, which said you can't give a kid a life sentence if you haven't thought about whether or not this kid is someone who deserves it. Have you adequately thought about who they are and whether or not their individual characteristics, the hallmark attributes of youth? Have you thought about all the things? Have you considered all those things before you before you imposed the harshest sentence possible that you could give to a kid? That was Miller. Miller is held to be applied to everyone in a decision called Montgomery v. Louisiana, that it didn't just mean from the moment of June to whatever the hell, December 12th. There we go. 112 was my first curse. From the date in June 2012 going forward. U.S. Supreme Court's decision in Miller applied to everyone. Montgomery v. Louisiana said it applied retroactively. Then in 2021, and so most of our story is going to sort of begin 2021 to the present day, or actually to about 2 weeks ago. In 2021, the U.S. Supreme Court took another case in this sort of world of youth-specific issues. It was a case called Jones v. Mississippi. And Mr. Jones, and it's important to remember just as we're thinking about these things, Mr. Jones was someone who was serving a mandatory life sentence. He received a new sentencing hearing after Miller v. Alabama. So he had the full kit and caboodle of a Miller sentencing hearing where they introduced all sorts of adolescent development records. And at the conclusion of that new sentencing hearing, the court decided to impose I'm still going to give you life. I still believe you deserve a life sentence. The attorneys in Jones v. Mississippi took that case up to the United States Supreme Court. And in Montgomery v. Louisiana and in Miller v. Alabama, when they were talking about kids and how kids are different, what they were talking about is sort of this notion that there are some kids who can get life, and some kids that can't. And the difference is, are you permanently incorrigible beyond the capacity for rehabilitation, or are you, oh goodness, what's the positive side of that? The positive side is transiently immature. Are you a kid? Are you like someone who, the word transient is there. So basically that means you're going to change. Like, are you capable of growth? Are you going to sort of grow out of this and become a different person down the line? And so transient and mature, you can't get life. Permanently incorrigible, you can get life. But then the US Supreme Court said, like, let's be real super clear. We're not requiring a factual finding to decide A or B. You're not required to do that. You're not required to say anything, but that's sort of, who can get life and who can't get life. But like, we're not going to require you to sort of make a formal factual finding about that. And then in Jones v. Mississippi, the attorney said, like, well, yeah, you said that, but shouldn't you say that they need to make a factual finding? So basically, even though the US Supreme Court had said no factual finding was required, in Jones v. Mississippi, who had a full Miller resentencing hearing, the attorneys asked the court to say, like, yeah, sure, he did get a full Miller resentencing hearing, but the court didn't make a factual finding that he was permanently incorrigible, and so therefore you can't give him life. And the US Supreme Court, to my eyes, not surprisingly, said, hey, yeah, we already told you you didn't have to make a factual finding. Why did you ask us again? We told you. And so the US Supreme Court said no factual finding is required and denied Mr. Jones his request. And the US Supreme Court said a really, like, they try to get things in a sort of a pithy, sort of short and to the point kind of way. They said the availability of, like, discretion. Basically, if a judge had discretion to consider your youth and to make a decision of what sentence it wanted to give, the availability of discretion is both constitutionally necessary, check, and constitutionally sufficient. So basically, just if the judge had the ability to give whatever it wanted to give, be it life or lower, that's going to satisfy the Eighth Amendment. So meanwhile, Illinois has sort of been a little bit ahead of the curve, both positively and negatively. So Illinois, after Miller came down, Miller was applied retroactively in Illinois well before the US Supreme Court got to that decision. Then Illinois applied Miller to not just people who had a mandatory life sentence, but also said Miller applied to people who got a discretionary life sentence, where a judge had the ability to give something less than life, usually 20 to 60 years, but chose to impose life. And the Illinois Supreme Court said that Miller applies in those circumstances first, and the judge has to make a determination about whether or not you deserve that sentence. Illinois Supreme Court also got the jump on Jones v. Mississippi in a case called People v. Ashanti Lesby, where they said, yeah, no magic words are required at the time of imposing a sentence. Like, we're not requiring you to make any sort of formal fact finding. You just have to adequately consider youth. And so the Illinois Supreme Court had already sort of landed where the US Supreme Court did land in Jones v. Mississippi. But then Jones v. Mississippi sort of threw a wrench out there into the world, and I'll come back to that wrench a little bit in terms of the idea of discretion alone is all that's needed. I'll real quickly talk about three Illinois Supreme Court decisions that have come down since Jones v. Mississippi. Well, four I'm going to talk about. First being People v. Dorsey. And that sort of was another, Illinois had applied Miller and its reach to people who had mandatory life sentence, applied Miller to those who had discretionary life sentence, and then applied it to those who had a de facto life sentence. So basically a life sentence, a number so high that it's the equivalent of life. And that case was People v. Dimitri Buffer, where the Illinois Supreme Court set the line at 40 years. They said that any sentence greater than 40 years is a life sentence when imposed on a juvenile, on a youth. And then in People v. Dorsey, the court was being asked, like, well, how do we count to 40? Because Illinois, what undergirds a lot of the conversations that we're having are all built on this, these protections found in the U.S. Constitution, the Eighth Amendment, which protects against cruel and unusual punishments, and also protections found in the Illinois Constitution, which ensures all sentences should be proportioned according to the seriousness of the offense, but also with the objective of restoring someone to useful citizenship. So it's sort of it's Article 1, Section 11 of the Illinois Constitution. It's a parallel. It's a friend of the Eighth Amendment. It's actually, it does more than the Eighth Amendment. But when we sort of try to determine the reach of the Eighth Amendment and the Illinois constitutional protections, it is based on an evolving standard of decency that and this came out of a decision in the 1950s from the U.S. Supreme Court, which basically said like the Eighth Amendment is something that grows and changes as society grows and changes. So just because something was cool in the 1700s or 1600s when we, I don't know, burned women and did all sorts of bloody awful things for a long time, just because things were okay at the time of founding, and lots was super bad at the time of the founding of our country, that's not the end of the story in terms of like how we define what the Constitution protects. That as we get better, the Constitution gets better. And so, and how do we do that? It's sort of like we look to see what's happening out in the country to make that determination. And so you are always looking at how society is improving. And I'm going to get to that a little bit more later, because you do look to see like how laws have changed. And in some ways, we see how laws have changed in a positive way. But the reason I started down this trajectory is that sort of from, certainly from 1980 to the middle of the 2000s, our laws weren't necessarily changing for the better. Things have gotten progressively worse. And so when we were trying to count to 40, how do we define a life sentence? We had to ask the question of like, well, are we talking 40 actual years? Or are we talking 40 years based on the truth in sentencing? Because in 1998, Illinois decided to take a boatload of money from the federal government to build more prisons, and changed, and that was actually 1996, that's when they first got the money. And they reformed our system of sentencing, where individuals used to get 1 day of good time for every day served. So if you got 80-year sentence, you would do 40 and get an additional few days, months kicked in. But, beginning in 1998, for first-degree murder, you would do every day that that the court gave you. So in Dorsey, he was a 14-year-old, which is an important way to start any sentence about People v. Durrell Dorsey. He was a 14-year-old who was found guilty of a couple of different offenses, and the judge wound up giving 76 years total. Cumulative sentence added up to 76. But Mr. Dorsey was eligible for day-for-day good time credit. So he was going to wind up serving, or, best case scenario, around 38 years. And so in People v. Durrell Dorsey, the Illinois Supreme Court was asked, when defining a de facto life sentence, do we count the actual number of years that one has to serve? Or do we just count or do we just look to the number the judge gave? And the Illinois Supreme Court said, we look to what they're actually going to serve. And so Mr. Dorsey was not serving a de facto life sentence. And so therefore, none of these additional protections matter. And then for reasons known only to a justice who I believe is no longer a justice of the Illinois Supreme Court, I think was voted out. Thank you, Illinois electorate. They threw in a couple of problematic things. Like first they said, yeah, here's what we're saying about, the you know, the notion of truth in sentencing, like, you know, we're not going to count, like we're like, he doesn't count because he's going to serve less than 40 years. They said, oh yeah, there's that decision in Jones v. Mississippi, and maybe that changes some of the stuff we said in other cases. And then they went over to the Illinois Constitution, which hadn't really been raised in that case, but they said, yeah, Illinois has always cared about kids, so maybe the Illinois Constitution isn't necessarily your friend here. So like that was the first sort of like tremor in the force. Maybe not the first, but it was definitely like one sort of indication that like things have taken a turn in a bad direction in terms of how that court was going to be treating these cases. Everything I've said up until this point has been talking about additional protections for people under the age of 18. But we know that, you know, the reason why we even have those cases was based on a newfound understanding of adolescent brain development, which that basically that talks about that when you're a kid, you do not understand, you can't comprehend in the same way that you do as an adult. You can't foresee consequences in the same way. You can't make rational decisions in the same way. You are influenced by just the presence of others in ways that you aren't necessarily later. You stay up later. I don't know. I go to bed very early because you know, that's just what happens. You get older and you decide like, I don't want to be out. I want to be in. And so your life changes and things sort of shift by virtue of that. But there's no, you know, no magic thing happens the moment you turn 18. And the brain development science that all this is based on shows that you're still a work in progress, at least until you're 25. And so, which, you know, is the easiest thing for anyone to understand, because 26 is when you can start renting a car without having to pay a boatload of extra money. Like, so there's magic in money, apparently. Like that's the one area where like everything sort of like does align when financial interests are at stake. You know, that's when the world, in terms of, you know, that there's a better understanding of sort of like, yeah, now we're going to sort of hold you to a different standard from 26 on, but our courts are still figuring this out. And so Illinois, the Illinois Supreme Court has repeatedly held open the idea that, yeah, the Illinois Constitution probably adds some extra protections for emerging adults, for people that are 18, 19, 20, 21, maybe. And they have sort of kept sort of like hinting, like, yeah, we kind of think there's something there. There's a there. We just don't know what that there is. And so one of the individuals who has been sort of pushing this issue forward is a individual, Antonio House. And he was a co-defendant, actually one of our jail op guys in Illinois. And he was accountable for the actions of someone else, got a mandatory life sentence. And repeatedly, the appellate court has said, like, I think this is the guy, this is someone that deserves to be resentenced. Like, he was an emerging adult who got a life sentence, and the court couldn't take youth into account, and that doesn't seem right. And so Mr. House should get a new sentencing hearing. But that keeps getting thwarted. And so the Illinois Supreme Court had Mr. House's case in front of them again. And in October of 2021, the court said he doesn't, like, the appellate court was wrong to give him a new sentencing hearing, but did not deny him entirely, but sent him back to the circuit court to further develop his case, to basically further show the work as to why he is more like a kid and deserving of these extra protections than he deserves to be treated like an adult and given a mandatory life sentence, which is what he otherwise would serve. And so that too is sort of frustrating because, you know, I mentioned earlier that language in Dorsey about how the Illinois Supreme Court believes that Illinois has always given these greater protections to kids. The one example that they can cite for that is People v. Leon Miller. And Leon Miller was sort of Illinois' Miller. Is a case from 2002. And it was like a perfect storm of awful type of case where he was automatic, like he was a kid, so he was automatically moved up to the adult system. He was there by accountability, and so he was going to be automatically treated the same as anyone else. And it was a multiple victim case, and so he was automatically going to receive a life sentence. So it was sort of like a triumvirate of awful had happened in his case, and based on those facts, the circuit court judge decided that he wasn't going to give him a life sentence, gave him, I think, 54 years, something like that. And the Illinois Supreme Court got that case and said, yes, the Illinois constitutional, under the Illinois proportionate penalties, with this sort of like triangle, Bermuda Triangle of like three terrible things all overlapping at the same time, he deserves that extra protections, and affirmed the finding that his sentence was unconstitutional. Great, wonderful for Leon Miller. And then a number of individuals tried to raise the same claim, and almost every single one of them lost. So this idea that that Illinois has always done this wonderful thing for kids is great if you're the unicorn, like the one individual that the court decided to give that protection to, but for everyone else, it amounted to a whole lot of nothing. Like, I think one, maybe two people ever got significant relief based on Leon Miller. Everyone else was just like, well, you're not Leon Miller, so you don't get, screw you, you don't get anything. And so it's true, there have been instances where Illinois has provided these greater protections, but how meaningful they are is an interesting question. As I was saying to someone here this morning, as we've been giving we were giving mandatory life sentences to individuals in Illinois beginning in the 80s and certainly in the 90s and 2000s. I would go back and look at some of their earlier direct appeals, and in many of those direct appeals, people raised the very same issue that ultimately was successful in Miller v. Alabama. They would say, like, it is unconstitutional under the 8th Amendment to give me a mandatory life sentence. What are you doing giving a kid a mandatory life sentence? And the Illinois courts were like, no, it's cool. It's fine. So the notion that Illinois has always had these greater protections rings a little bit hollow when you actually sort of look to see how Illinois has actually treated kids, at least as they've done in the last 40 or 50 years. I try to, I like to add a little bit of positive to like this onslaught of negative that I've been giving. And so one instance of positive, which isn't really all that much for this group, but it's worth noting. There's a case called People v. Denzel Stewart, and that was another decision from, I think, 2022. So I spent some time on the awfulness of 2021, 2022. Here's one good thing that happened in 2022. And that was a case that had to do with, so Illinois has ways to make your sentence worse, higher, if you've previously done stuff. So like, it's called recidivist statute. So like, if you're a recidivist, if you pick up an offense and pick up another offense and another offense, they're going to start to automatically treat you differently. And so one of the biggest elevators for that is called mandatory X by background, where if you have committed a series of class 1 or class 2 felonies, the third time you do that, if you pick up another class 1 or class 2, you're no longer going to be sentenced as a class 1 or class 2. They're going to automatically sentence you as a class X. So your range went from like 3 to 7 or 4 to 15 up to 6 to 30, and potentially higher. And there was and then some of the laws started to shift regarding kids. And we took, like, Illinois has, I talked about Leon Miller, and most all of our Miller impacted people in Illinois. They were people that were automatically treated as adults because they were a certain age when they picked up their case, and Illinois had a statute saying if you're a certain age and you do a certain thing, you are not like you do not pass go, you're going to be up in adult court. And so Illinois has changed that law, and they have taken the list of offenses that automatically kicked you into the adult court from like 11, and they reduced it down to 3. And it used to be everything from 15 and up, and they raised that to 16. And so there were a lot of people that picked up a class 1 or a class 2, which maybe no longer would have automatically moved them up to adult court. And so Denzel Stewart, suffice it to say, one of his qualifying early offenses was for something that if he had done the case today would have stayed in juvenile court, but for a transfer hearing. And so the Illinois Supreme Court, in trying to decide whether or not we should count that earlier conviction, then look to a later legislative enactment, the Safety Act, the big omnibus criminal justice safety thing that was like over 1,000 pages long. Buried in the intricacies of that was a change in the law where for these recidivist provisions, Illinois was no longer going to count offenses like cases you picked up before you turned 21, which again makes sense. Like if the whole point of like when you're a kid is that you don't necessarily foresee the consequences of your actions, why are we counting those mistakes against you later on to treat you more harshly? But Denzel Stewart is a bonkers Illinois Supreme Court decision where they said that big ass change in the law that happened in the Safety Act was actually just a clarification of what the law always was. And ask anyone who was involved in writing that law would tell you this wasn't a clarification. We were trying to change things for the better. But the Illinois Supreme Court says like, well, they saw this open question and the General Assembly answered it as a clarification for everybody. And so therefore, you would not automatically raise someone by virtue of their prior convictions. And so that is an area like in the first Jurassic Park, you know, the scariest dinosaurs are the ones that start to test the fences, that are trying to figure stuff out. And so we're testing the fences right now to sort of see just what else we might be able to do with Denzel Stewart. And so we don't know. Maybe it was just sort of a one-off, like one little, like they're throwing us this little bone while they're screwing us on all the other sides, but maybe there are ways in which we can sort of take that and push, you know, try to push things forward. All right. And now I will quickly talk about, so in the world of emerging adults, which is sort of, I started there with People v. House. The Illinois Supreme Court remains somewhat convinced that there probably is some ability to sort of raise a constitutional claim for someone past the age of 18 or up, based on sort of showing how you are more like a kid than you were like an adult. But just who gets to raise that claim is open and subject to debate. I don't know how to do this without getting super complicated, but basically, you know, and maybe I could bring Nelson in to sort of help explain this too. Like the way, once you're like, you know, everyone who is found guilty of an offense in Illinois, you get an appeal. You have, and that's the job I used to do 15 years ago. Gosh, even more now. Ugh. Anyway, that's a job, like everyone gets an appeal, and because you did something that subjective, like the possibility of prison time, the state will give you an attorney for free to handle that appeal, and so everyone gets an appeal. And that's sort of like your one sort of clear shot at your underlying conviction. Down the road, if something else comes up that you want to challenge, or if there was something that should have happened in that direct appeal and didn't, there has to be another way into court. And so the easiest and cleanest and the proper way to do that is called a post-conviction petition. So sort of direct appeal is sort of like you commit an offense, you're charged, you're found guilty, you have a direct appeal. Like these are all on a single line up and down. A post-conviction petition is sort of off to the side, and so it's called collateral. So it's not a part of your direct line. It is sort of off to the side. It's a separate thing, but you're still going after basically what you can and can't raise in a post-conviction petition is that it has to be some constitutional error that should have been like basically either could not have been done on your direct appeal or should have been done and wasn't. And so it's a way to raise new constitutional claims. And so like when Miller came down saying your sentence was unconstitutional, you filed a post-conviction petition because that's how you address constitutionality, and you file it there. But so and Illinois has written it into the code to give everyone the ability to, anyone who's incarcerated, you also have the ability to file a post-conviction petition. But how many post-conviction petitions? Everybody gets one, and you can file more. But now we're no longer sort of in the land of like what the courts are willing to protect, because now the worry is, are you a nuisance? Are you a frequent filer? Are you someone who's complaining about everything, and you're gonna, because you're bored, you're going to file another post-conviction petition? And so they started creating hurdles to get back through that door. So the post-conviction petition opens the door for you to go back after your conviction. But if you try to do that a second, third, fourth time, it's going to be really, really hard. And the Illinois Supreme Court recently talked about that a successive petition, and I think their language was highly disfavored. So they don't want you doing this. And so they're going to make it really hard. And so there's this test of who gets to do it. And you basically you have to pass this two-part test. You have to explain why you didn't do it before, why you're just saying this for the first time now, and then why you were harmed by virtue of not having raised it before. Harm is usually pretty easy to establish. I'm serving an unconstitutional sentence. That I'm being harmed by that. But the question about why you didn't raise it sooner can be hard. And so this is the thing where people are starting to get screwed, because courts are saying Illinois has always been good to kids. Illinois has always taken mental impairments into account. And so even though 30 minutes earlier in this diatribe that I'm providing you today, I said that all of this case law is based on an evolving standard of decency marked by the progress of a maturing society. So as we get better, the protections get better. Courts are also engaged in this legal fiction as though everything has always been great for kids, or everything has always been great for young adults. And so why are you coming to me now saying that I should get something, that you're deserving of something? And so that is that was the badness that was hinted at in the Dorsey decision, has now sort of come home to roost in People v. Robert Clark. Robert Clark was a 24-year-old who had substantial mental impairments that I believe had him functioning more at the age of 13 or a 14-year-old. And he had filed on direct appeal. He had actually challenged his sentence, saying that it violated the Illinois Constitution. And they had filed a couple of other post-conviction petitions. And then after Miller and Harris came down, and there was a separate challenge in a case called Cody, had raised another post-conviction petition, arguing that under the Illinois Constitution, you know, he was that his intellectual capacity was that much more like a child, and he's an emerging adult, and so therefore is deserving of these extra protections. And there was a conversation happening earlier today among OSAD attorneys, like trying to like determine just how bad things are by virtue of Clark. So I don't know, like if we can find a way to sort of like get around the badness of this decision. But what this decision is trying to do is to shut the door on these successive post-conviction petitions for emerging adults and for people trying to raise these sort of like Miller expansion type cases. This is just talking about like who gets to file more than one post-conviction petition. They are not suggesting that if you have not earlier filed a PC, if you're on your first post-conviction petition, you probably are still okay to raise these types of claims. If you're like a 19-year-old and they didn't adequately consider your youth, you should still be able to sort of pursue something if you are on your first PC. If you're on a successive PC, it's an open question. Certainly that like up around 24, Clark is super bad and is going to be a huge obstacle for us to sort of like figure out a workaround. There is a and so there's two more cases I want to talk about, but these aren't decisions. These are cases that are pending in the Illinois Supreme Court. One of them is called People v. Moore/Williams. So it's actually two defendants. So maybe I lied. I'm going to talk about three cases, but one of them is a twofer. So it's one case with two defendants, Moore and Williams, and they were both 19-year-olds who are raising this type of an emerging adult claim based on Miller and all of its added protections of youth. And the issue in the Illinois Supreme Court was, and they were both people trying to file successive post-conviction petitions. So they were both trying to like crack open that door again to get back into court. And they were trying to hit that two-step, the two-part test of like what, you know, like they were prevented from raises before, and they were harmed by not being able to raise it before. And they are trying to say that like, yo, like this should like, we didn't know any of this about brain science when I was found guilty in 1987. And that's, I'm making up a timeline there. So until court started to recognize and give these additional protections, I had no reason to file a petition seeking to raise that claim. And like I said earlier, if you go back in our Miller, the folks who have been resentenced post-Miller, you'll find in some of their cases on direct appeal, they raised this very issue and lost. And so it makes it really difficult. And some of those decisions were published. So like when I'm an attorney working on a case and I see that something has been raised and lost, that's a reason not to raise the issue, because you don't want to piss off the court. Like you don't want to raise something that you know will lose when you've got something else that might win. You're not going to file another claim that will lose because there's controlling authority saying you lose. So you're not going to do it. Moore and Williams are going to answer, like, they're going to probably answer the question about just how bad that Robert Clark decision is, because they were both 19 and it's laser focused on just this issue of, is there enough here to allow them to get into court, to basically like, were they able to pry the door open enough to get in and raise this claim? So that's all the world of emerging adults. And then the last case I'll talk about is People v. Michael Wilson. And so this is that other sort of like scary line that came out of that Dorsey decision, where the Illinois Supreme Court said, yeah, when we decided Holman saying Miller applied to discretionary life sentence, like we didn't have Jones v. Mississippi. So I don't know, maybe, I don't know. What do you think? And Michael Wilson is going to answer that question about whether or not Jones v. Mississippi is it going to have a impact on our on the Illinois Supreme Court's previous decision. Mr. Wilson, Michael Wilson, 14 years old. So it's another 14-year-old who got a 59-year, 59-year sentence, who's challenging his constitutionality of that sentence. But it was, it wasn't a mandatory 59. It might have even been a straight like 20 to 60, and the court, gave 59. But back when I, started talking about Jones v. Mississippi, where the U.S. Supreme Court said the availability of discretion is both constitutionally necessary and constitutionally sufficient. Is that going to be will that be true here in Illinois? Mr. Wilson's judge had discretion. And so was that sufficient in his case to take youth into account before giving a de facto life sentence? That case was argued in the fall. We have not gotten a decision yet from the court. There are new judges on the bench, and so that might have an impact on the direction the decision goes. And in that CRIIC decision, like one tiny silver lining to it is that it doesn't do any, like, it had the opportunity to sort of like, who's here with us right now? I can't pretend any longer. It had this ability to take a shit on another decision if it wanted to, but it chose not to. So they were more limited in their scope in terms of what they were going to talk about. And so it's possible that those same judges who just did that terrible decision in Robert Clark might still have something good to say in Michael Wilson. I don't like talking like that because that's giving potential hope where right now I can't be positive or negative. But I just note that they were very sort of intentional about how they wrote their decision in Clark, that they could have done more sweeping stuff like they did in Dorsey, and they did not. So we will have to see. The good news to sort of all of this, which is how I wanted to end, which is that evolving standard of decency marked by the progress of a maturing society, like the way courts determine that is by looking to see what the General Assemblies are doing. What are the legislatures doing? That matters in the national landscape, and it matters here locally as well. So in the national landscape, as you all know, HB 1064 was signed into law last week, and which means Illinois tipped the scale for our country. In our country now, the majority of states have eliminated life without parole. That is how you raise things in the US Supreme Court, to show something that, like, they had it, like that question was in front of the court back in 2012 in Miller v. Alabama. Should we abolish life without parole for all kids? And the court chose not to reach that, but they could have by doing a state count. And if they had done a state count back then, we would have lost, because there was only like 12 that had abolished it at that point. But since Miller, the arc has shifted, and we are moving into a world where now the majority of states, plus the District of Columbia, and then a lot of states don't have anybody even serving this sentence. So like it is exceedingly rare across the country to be able to even impose the sentence. And now is not the time to try to go to the U.S. Supreme Court to ask them to do anything. The only thing you should be asking the U.S. Supreme Court justices to do is retire. And beyond that, just let them just be, and they can fine. They go wear your robe and decide about money stuff, because we don't need you anywhere near the rights of human beings, because it's not a good time. But in our Illinois courts, we also have to be like using the General Assembly to help shift and grant these added protections. Like Denzel Stewart won because of a change brought by the Safety Act, which had nothing to do with his case, but was then used to support his ultimate success. And Illinois has now abolished life without parole for kids. That will be another arrow in the quiver of showing that the evolving standard in Illinois is that we are giving more protections to kids. And, you know, if we can make it retroactive, if we can get expanded firearm enhancement protections, for you know, like everything we can do to sort of move that needle up, like what Restore Justice has been focused on in terms of at least those under the age of 21 and not just talking about 18 as a bright line, this will all be helpful. And so I sadly end with a plea that like we need you. Like us lawyers, we're just screwing shit. We're not helping right now. And the General Assembly could help. And so like everything you guys can do to organize and help make things better will then make things better in the courts, because that is what we will use to show that you know, Illinois hasn't always been good to kids, because we moved them all into adult. We took away their humanity and we treated them without, you know, without any consideration of their youth. That's how we had over 100 individuals serving a life without parole sentence. We weren't being great to kids. We had, you know, people, we had 800 people, so however many people were like impacted by the buffer decision. We were not being good to kids in Illinois. We've like been doing everything in our power to treat them like adults. And so like the more that we can do and show of how we are no longer like that, will help sort of reimagine and sort of reignite that Illinois constitutional protections that will ultimately help the emerging adult population. So
Yay. I'm going to stop the recording so you can be truthful now.